A lot of my videos focus on estate tax planning, asset protection planning, particularly using trust, and then also making sure to use the best trust laws that are available. And I like to do that planning in South Dakota. So videos really focus on that. Today, I want to focus on something that is probably more applicable to a greater amount of people than those three things that I usually focus on. So today I want to focus on revocable living trust and what assets should go inside a revocable living trust. So let's get into it. So a revocable living trust. At one point in estate planning history, a revocable living trust would have probably been considered only for the mass affluent. And that's just not the case anymore. Really, anyone can take advantage of a revocable living trust. So first, what is a revocable living trust? And then why you want to take advantage of it. So revocable living trust is simply that. It's a revocable trust. And the importance or the significance of it being revocable is that it has a lot of flexibility. It's really tax neutral. There's no change in your income tax situation. And for all intents and purposes, the way that you interact with your assets doesn't really change either. So you, the client who set up the revocable living trust, are the trustee, meaning you manage those assets. And then you're also the beneficiary of that trust, meaning that you benefit from those assets, right? So as I said, for all intents and purposes, you still have that same relationship with those assets as if they were in your individual name. Now, the reason that you put assets in a revocable living trust, the most popular reason is to streamline administration. So what do I mean by that? Streamline administration. So when you pass away, any assets in your individual name have to go through the probate process of the local district court, which is overseen by the probate judge of that court. So you have to submit an inventory of assets. You have to submit values of those assets. You have to submit information regarding who the heirs are going to be of these assets. So it's a very lengthy legal process that you have to go through. And a lot of times, almost always, when a person passes away, the last thing that a family wants to deal with is this legal formality of transferring ownership from that person who passed away to the other generations. By changing nature of legal ownership from you as an individual to a revocable living trust, you're able to completely avoid probate. Now, what assets go into revocable living trust? So each state has different rules around when you can avoid probate. So it's called dispensing with administration. Different states may call it different things, but that's typically what it's called. So here in Texas, an estate that has less than $75,000 of assets in it can dispense with administration. So you still have to submit some documents to the probate court, but once you do that, you don't have to go through the full-fledged probate process. Same thing in other states. So the idea is that you're putting your assets in this trust. A lot of times, people's cars and their property in their home, their clothes, their furniture, their electronic equipment, maybe they have boats, they have pieces of art, they have antiques and collectibles. These things alone can push people over that probate limit that makes them have to go through it. So these are the type of things that we put inside of trust. Tangible personal property. So I just mentioned those things. Those are basically, your clothes, your furniture, your electronic equipment, your computers, your artwork, anything inside your house. You assign those assets to the revocable living trust. And the way that you do that is just your attorney creates what's called, usually a one-page document. It's just called an assignment of tangible personal property. And it just says you're assigning these assets to your trust. Any assets that you currently own, any assets that you own in the future, you are assigning those assets to the trust. The other things that you want to put in there are often are real estate. So maybe it's your personal residence. Maybe you have assets in different states. A lot of times people will have a vacation home. Maybe it's in Colorado or Wyoming or Florida. Maybe it's even abroad. There's different things that you have to consider. You don't want to get pulled into the probate process in another state or another jurisdiction because you have real estate there. So to avoid that, to avoid having to use attorneys in multiple jurisdictions, you assign that real estate to your to your revocable living trust. Other things that you would want to put in there is any of your cash accounts. So any type of bank account that you have, whether it's a savings account or a checking account, put those in the name of the trust. Well, I'll keep going here and then come back to that. But brokerage accounts, securities accounts, you want to put those, your investment accounts, you want to put those in the name of your revocable living trust as well. I'm trying to think what else there might be. Those are the big things. Now, sometimes people do talk about that they can have transferable on death designations or payable upon death designations. And yeah, that is a way to avoid probate. But I often tell clients that if they're going to the trouble to set this estate plan up and they're creating this umbrella, this kind of holding umbrella that's going to streamline all of their assets, why not put everything under that? I personally wouldn't leave anything that's kind of hanging outside of that. So I think there's a lot of value in creating these legal structures that go ahead and hold everything. A lot of people will ask, well, what's the disadvantage of doing this? So this is the disadvantage. It takes time to do this. There is some heavy lifting with this implementation phase of your estate plan because you're having to contact banks and financial institutions. You're having to get file deeds for your real estate. There's different things that you're having to do to get assets titled in the name of the trust. Is that the end of the world? No, but it does take a little bit of heavy lifting to get that done. But once you get it done, then there's a huge sense of relief because you have everything under one, again, umbrella, type of holding umbrella that has everything streamlined. So a revocable living trust is going to cost more than just a estate plan that only has a will that's going to send you through the probate process. And this might be controversial in some circles. Financial advisors and attorneys, other people will say that there is a certain minimum amount of wealth where it makes sense to have a revocable living trust to avoid probate. And I don't think that there is a threshold. I think that if you want to avoid probate, regardless what your net worth is, then it makes sense to have a revocable living trust. The other thing is that by avoiding probate, things are kept private. Probate is a public process that anyone can access that information regarding who your family is, who's receiving what, how much they're receiving, the value of your assets. That's often how we know things about celebrity estates, is they didn't do trust planning to avoid probate. But my point in bringing this up is often if an attorney is pushing you to a will and telling you not to avoid probate, it's because that attorney, one, doesn't know how to do trust planning, or two, they might make more money doing probate work than they actually do estate planning. And I've seen forums where attorneys or estate planning attorneys are talking about how much they charge clients. And I've read that some attorneys, they heavily discount estate planning because they want to do the probate work where they charge significantly more for the probate work. So, you're the client, you make the decision, but when it comes to the revocable living trust, you can put pretty much any type of asset that you want in there, particularly to avoid probate.